Good morning. This is JP Sarmiento, Sarmiento Immigration Law Firm. For our success story posting for May 22, 2020, it is a J1 no objection statement waiver approval for a Filipina client in Covington, Kentucky. Now, the J1, if you're a J1 visa holder and you're subject to the 2-year foreign residency requirement, before you become eligible for certain visas or for adjustment of status, green card, you have to either go home to your home country first for 2 years or you have to get a waiver. Different countries have their own different waiver requirements. For Filipinos, they have three distinct ways for a no objection statement waiver. One is if you have a U.S. citizen or permanent resident spouse. Two is if you have a U.S. citizen or permanent resident son or daughter. And three, if there are any humanitarian exceptions, humanitarian reasons, usually medical reasons for J2 derivatives. My client was married to a U.S. citizen, and pursuant to one other requirement for the Philippines, you have to have completed 2/3 of your program based on the DS 2019. So my client came here in August 2016 to work as a teacher. January 2018, she got married to a U.S. citizen. Retained our office in November 2019 because that was past the 2/3 mark of her entire program. So we filed the J1 waiver application to the Department of State on November 27, 2019. And then on December 16, 2019, after we do all the Philippine no objection statement requirements, which requires notarization of documents, having it apostilled by the Secretary of State, doing the no objection statement form, certificate of participation form. We do an affidavit of authenticity, ensuring that the client has an original clearance letter from the latest employer from the Philippines, a Senomar. So all this stuff, we submitted the documents on December 16, 2019. Eventually, the Waiver Review Committee in the Philippines, the Exchange Visitor Program, or EVP, issued the approved no objection statement and forwarded it to the Philippine Embassy in Washington, D.C., who eventually issued the official no objection statement for the Department of State. And then on May 5, 2020, the Waiver Review Division for the Department of State issued a favorable recommendation. Based on that, you can already apply for the green card. And then eventually, after you get the 612 approval notice, you can present that at the interview. Because on the form itself, on the updated form itself, the 485, it allows you to already apply simply based on the waiver recommendation by the Department of State. But fortunately, though, 1 week later, May 12, 2020, the USCIS issued the I-612 approval notice for our client. So now she's really eligible for adjustment of status based on an I-130 petition from her U.S. citizen husband. So if you have any questions pertaining to something similar, feel free to call our office. This is JP Sarmiento. Our consultations are free. My phone number is 216-573-3712. You can also email me at jp@sarmientoimmigration.com. Any questions pertaining to something similar or anything immigration related, feel free to contact our office. Thank you.